We felt like it was important, to write about these things and to try to determine the truth, because that's really what we care about. At the end of the day, is the truth. Whatever it is, if the officer is exonerated, that's great. That inspires public confidence, and they should be. The public should know that, so that there's not some allegation floating out there against them that's not true, right? And conversely, if they've done something wrong, then the public deserves to know that, especially the people that could potentially be prosecuted as a result of that police officer's word.
I'm Justin Silverman of the New England First Amendment Coalition. This program is brought to you in part by the Society of Professional Journalists Foundation, which supports our First Amendment and Free Press program, where we take a look at the role that journalism plays in our democracy. I'm here today with Brad Patrician with the Worcester Telegram and Gazette. Brad, thanks for joining us.
Glad to be here. Thanks for having me, Justin.
Brad, I'm so glad to have you on because there has been a recent development in a public records battle that you and your newspaper have had for many years, and we'll get to that in a moment. But I think this particular battle is not only timely because of this recent development, but also because it has to do with the Worcester Police Department and issues of law enforcement accountability and transparency, and more generally, the Massachusetts Public Records Law, which, as we both know, could use a lot more improvement and some additional reform, more so than what was done in 2016. So you've got a number of very interesting, relevant issues here that I'd like you to go into. But in doing so, if you could please start by sharing with us the long history that the Telegram and Gazette has with the Worcester Police Department, beginning with a very important court decision in 2003 related to police records and, more specifically, internal affairs documents.
Yeah, so we have a history stretching back with the Worcester Police Department. It has been a struggle to get records from this department for a couple of decades now. And although I wasn't at the paper back in 2003, we filed a lawsuit actually that's very similar to the lawsuit that we're currently engaged in, just essentially looking for internal affairs records, which are, when the police are policing themselves, when they're looking into allegations of misconduct, they produce a report called an internal affairs record. And those records are often used to determine whether an officer is going to be disciplined, whether they're going to be fired, a whole host of different outcomes. So back in 2003, we had trouble getting these reports from the Worcester Police Department and filed a lawsuit. And at the end of that lawsuit, which the city battled tooth and nail and took it up to the appeals court, the appeals court ruled in our favor and essentially said that these records are so important to the public's understanding and the confidence that the public has that the police are, acting with integrity and within the bounds of the law, that these are things that the public has a right to in Massachusetts under the public records law, reaffirming that. And it was really a landmark decision at the time. It's been cited in a lot of cases and a lot of litigation since then involving, newspapers like the Globe and others. It's cited frequently in briefs. And, back then the city had essentially argued, well, there's an exemption to the public records law that protects personnel information. Like, for instance, if there was somebody at the DPW that, was caught doing something maybe untoward and they were disciplined for that, that sort of thing, actually, a lot of times they can withhold. They can say, nope, it's a personnel record. We don't have to give it to you. When it comes to the police, though, it's a bit of a different story. The appeals court ruled that the city had argued that these sorts of records, these internal affairs records, should be considered personnel and that the public doesn't have to have them, essentially. It's a little bit of an oversimplification, but that's basically what the gist of their argument was.
If I could pause you there, Brad, because the court came in with this very important ruling, and I have some language here which I think is worth repeating because the court was very clear in its ruling when it came to these types of personnel records. The court said it would be odd indeed to shield from the light of public scrutiny as personnel file or information the workings and determinations of a process whose, and this is important, whose quintessential purpose is to inspire public confidence. So it's like very strong, lofty language to say, like, we need this information in order to hold police accountable so we can have confidence as members of the public that they're doing their job correctly, right?
That's absolutely the case. They said they said these records, these police records, why even do an investigation if the public's never going to be able to figure out, they need to make sure not only was something done, but how did the investigation unfold, right? Was it done in a way where, it was really thoroughly investigated, where something wasn't swept under the rug, where tough questions are being asked and people are being held accountable? If you don't have that, then kind of what's the point, right? So, they're basically what they said in that very strong statement was, and then the rest of the ruling was, police records are a different kettle of fish. They're just more important than, if say the DPW worker acts up or something like that. You might not be entitled to that. We can file requests, but they may be denied and exemption might be cited. But in the case of police records, that's the sort of thing they've said, no, this needs to be released because of the extreme power that police officers have.
So that's great. So we have this great ruling in 2003 saying the public has a right to these documents, even if they include internal affairs reports. So end of the story, right? Every request you made from that point on was granted?
Well, no. It has not always been granted. There's been other occasions where we've asked for things and we have not gotten them. My experience with this harkened back to, I think, 2016, 2017, when I had requested some of these some records. I had requested 12 records. Actually, it was 2018. I requested 12 records that had to do with investigations into complaints that a local civil rights attorney had made. This civil rights attorney in the city of Worcester, Hector Pinheiro, had filed a very long complaint with the DA, the local DA, Joe Early, with AG Maura Healey, and with the feds at DOJ as well. Very lengthy complaint, 750 pages, basically saying, hey, I do not believe that, I believe there's a problem in the Worcester Police Department and some of the elite units, the SWAT, and not the SWAT, sorry, the Vice and the gang units, and, had a long litany of complaints, including officers fabricating things, lying, things of that nature, and basically saying, I do not think that prosecutors in Worcester are holding police officers who engage in misconduct accountable. There's something that's actually being talked about quite a bit now, and I believe actually Rachel Rollins in Boston has committed to releasing her list today. It's called the Brady Giglio list, and it's essentially a list of officers who may have credibility concerns. And the keeping of such a list is not mandated by law, but the concept behind it stems from a ruling, and I don't remember the exact year, but it was some time ago, decades ago, ruling basically saying that you need to be making sure that you're turning over, if there's an officer or anybody that you're going to be calling in court, that the prosecution is going to be calling in court, if there are grave concerns about their credibility, as it relates to that proceeding that could bear upon that proceeding. For instance, if a police officer had been, many defense attorneys would argue, convicted of a crime in the past, or convicted of lying in a police report or something like that, that information needs to be turned over to a defendant who may have been arrested by an officer and might say, hey, I might want to use this in my defense. Now, a lot of times judges will say, well, that's not really relevant to this case, and strike it down. But the point is that you're supposed to know about it, so you have kind of a fair opportunity to contest the validity of maybe what a police officer or another witness might be saying against you, based on their credibility. So basically, these lists are something that are under the microscope quite a bit these days. And actually, like I said, today, I believe, actually, Rachel Rollins, I believe, is supposed to be releasing her list, if not today, very soon. But it's not something a majority of prosecutors do. There was a reporting out of WBUR recently. I think it's only 2 or 3 of DAs actually have such a list, and a lot of them do not. Worcester does not have a list. And so to bring it back to where I started here, the complaint that this civil rights attorney Pinheiro had filed was basically saying, I don't believe that these Brady Giglio warnings are being given properly as they're supposed to be under the law. I don't think the defense attorneys and the defendants are getting the information they need. And oh, by the way, here are I think there was about 20 officers or so that he basically was making some pretty serious allegations against. So we looked into the allegations. I read through all 750 pages of the complaint. I went to court to get records to see whether this sort of thing could be, how many of these complaints had something behind them, had they been dismissed in court, things like that. And I found that a number of them had been dismissed in court, as the attorney had written in his letter. And there were, a couple instances where there's one instance in particular where the judge in Worcester, the top district court judge, had said, actually, while he was dismissing one of the cases on constitutional grounds, had said to the prosecutor, there's this thing called the Constitution. Maybe they should read it. Referring to the police. And in speaking to a lot of lawyers in the county, that's not the sort of comment that they believe, a judge would kind of just throw out there, willy-nilly, and so, we felt like it was important, to write about these things and to try to determine the truth, because, that's really what we care about at the end of the day, is the truth. Whatever it is, if the officer is exonerated, that's great. That inspires public confidence, and they should be, the public should know that, so that there's not some allegation floating out there against them that's not true, right? And conversely, if they've done something wrong, then the public deserves to know that, especially the people that could potentially be prosecuted as a result of that police officer's word. So, we requested these records in 2018 from the Worcester Police Department pertaining to the 12 main cases that the attorney had brought to the fore. And we also requested something different as well. We requested, there's also something called the state police here in Massachusetts call it concise officer history. It's basically kind of like almost just a printout, a summary of an officer's history with internal affairs, like how many times they've been investigated, was it sustained, that sort of thing. Actually, the kind of thing that was released by the Minneapolis Police Department shortly after George Floyd and Derek Chauvin. And actually, the Minneapolis Police Department already had records online that would allow you, all systems differ, but it would allow you basically, as I understand it, to see how many complaints someone had fielded. So we basically asked for similar information to what was already, similar information that many departments already make public, including I've gotten those sorts of that sort of information, that sort of summary from the state police before. So we requested those things, and we were told it'd be about $3,800 to get the records, but it would only be about, I want to say it was less than $200, I think, to get the concise officer histories, the summative documents of the person's history with internal affairs. So, what we ended up doing was giving them a check for that portion of it. The last portion of it, that's a very large expense. $3,800 is a very large expense, but we figured we would get the concise officer histories. And we ended up, we ran a story on the allegations because they were out there. The feds had them. This was all this was public information at this point that anybody could request. And so we did the best that we could with what we had to try to tell people, hey, these are the facts as we know them. These are some of the allegations. This is what we know. And after we ran the story, was when we discovered, that the city was no longer amenable to turning over records. They actually told us
what kind of records, Brad? Just to clarify.
So we had so the summative documents that we had asked for, we had already given them a check, and they said, come pick up the check. We've decided that these records are actually exempt from public records law now. Whereas before they were going to turn them over before the story ran, but afterwards it was these are actually exempt from public records law now. And then I had subsequently asked them, okay, well, what about all the other records, that you had, agreed to release for $3,800? And they said, nope, everything now, everything. I think there might have been a couple files that they agreed to release at some point, but everything for various different reasons, various exemptions claimed under public records law could not be released.
But you have this 2003 decision that says that these types of records should be released. Now, all of a sudden, you have the Worcester Police Department saying, no, we consider them exempt. We're not going to give them to you. As a journalist, that, with your editors, those that you're working with in the newsroom, I mean, how do you respond to that? Because you have legal authority saying you're entitled to these records, and a police department refusing to recognize that authority?
Well, obviously, the way that we responded to it was to file a lawsuit to protect the public's right to know, to protect our access to documents that we have a right to, to protect, what we do under the First Amendment every day. We felt strongly that we were not going to, that this was something that was worth doing. This was something that was worth pursuing, and that, that this was in our minds so clear cut that it was something that we felt was important to do.
To be clear, this is a 2018 lawsuit that the Telegram and Gazette filed against the Worcester Police Department, essentially saying, hey, you're not following this 2003 decision. You're not providing us the records that we're entitled to under the public records law. As the court said in very clear language, 15 years ago, please, judge, compel the disclosure of these documents and help us report our story and get the information that we need out to communities.
Exactly. That's the way that we look at it. We're protecting the public's right of access here and our right of access to documents to allow us to do the work that we do, for the public every day. Like, there are certainly, and especially nowadays, there's a lot more people that are requesting records and looking into things and asking, probing questions about police and other matters. But, back when we filed this, that wasn't necessarily the case. The landscape has certainly changed just recently. And, that's what we do. That's what we get paid to do every day, is to ask the questions on behalf of society and work for people that otherwise, that they're not going to be necessarily asking when they're in their day-to-day, doing their day-to-day jobs, right? So
Yep.
so that's, we filed the lawsuit, and, we're still in the process. I'm definitely learning personally, that these things can take a lot of time. And certainly, we all know the courts are, overburdened, and there's a lot going on. And so, our lawyer, has argued in court that, he doesn't believe that the correct decisions have been made to this point, but we're hopeful that, that we'll prevail here, and we're confident.
Yeah, so this was the lawsuit filed in 2018. We're 3 years now into this litigation, but something interesting happened recently.
Yes, so we have filed this lawsuit, and we've been, going through filing briefs and filing for summary judgment and things like that, the normal court process. And it got to the point where a judge basically said, I think that this deserves a trial. He hasn't looked at the records. He felt like he wanted to wanted to have a judge look at the records before he could make a decision, I believe. And so it was winding its way here. And then obviously, things have changed in the last 6 months, given the public outcry regarding George Floyd. And one of the arguments that the city has made in order to say that they don't have to turn over these records is basically saying, well, there was this ruling in 2003, but they contend there have been rulings since then in case law that they say support their position, which is essentially that because these police officers are being sued civilly, we don't need to turn over these records that have been deemed to be public because there was a case where there was some finding that some records in litigation are protected. Our attorney, a very well-respected First Amendment lawyer in Boston, Jeff Pyle, he's argued very forcefully in briefs that is a misappropriation of that decision, and is confident that we will prevail. But in the meantime, obviously, we've been going through this process, and back when George Floyd took place, a little bit after that, a public discussion started in Worcester, a public discussion that really hadn't been going, hadn't really happened in a lot of places across the country regarding police reform, regarding, all these sorts of issues. And, there's been, pressure on the city council and others to act and things like that. And so our role being to get this information out to the public at a time when reforms are being considered, at a time when, this issue is at the fore, we asked the judge to speed this along a little bit and tried to talk to the city manager about it. He said he couldn't speak about it because of the ongoing litigation. He really kind of, didn't address many of our questions. And so, we've kept on going on, filing records requests, things like that in the normal course of business. And just recently, actually, when we got a records request back, the city had actually changed its position on one of the things we had alleged in our lawsuit. So our lawsuit had a couple different parts to it. One of it is we're seeking, the internal affairs records, but the other part that we pointed out during the litigation is that records that the city did turn over to us in the course of the litigation and also prior to that, so they have turned over some internal affairs records, ones that they contend that they can turn over, ones that aren't the subject of lawsuits and that have been fully investigated, things of that nature. But they black out the conclusions entirely. So you get it back and you're reading it and you get to read the body of it with some redactions. But then the last couple pages are completely blacked out, kind of the conclusions of what the chief found and what was recommended and things like that, which obviously, makes it really hard as a reporter to tell the public kind of what happened. So we had basically argued that this violates the spirit of the law, and the letter of the decision in 2003, pointing to exactly in the decision where it said, that withholding the conclusions, they'd actually addressed this exact point. And they found that the conclusions had to be released. And so we pointed to that in our lawsuit, and have pointed that out in a number of stories in the recent past. And so when we most recently got back a records request, the city had mentioned that it had changed its position on this and was now releasing the conclusions to the reports. They did not say, when I always stick to the facts, they did not say either way. They didn't say this was because of our lawsuit. They said actually that they had done an internal review of the best practices and policies in other departments. And I asked them for a copy of the review and asked them for, the policies, that they were referring to, and they said that none of those things were written down. It's not a written policy; it's just a practice. So, unfortunately, was not able to get, whatever they relied upon. And the city manager has since made some other comments saying that, basically the political climate that's happening right now, he felt this was the right thing to do. But interestingly enough, however, we still have not gotten clarity. I asked the question of whether the city's position is now that the public is legally entitled to the conclusions as a matter of law, as opposed to it just being a policy change. And they have declined to address that. So, these are the kinds of things that we think about as reporters and editors. We think about not only the short term, but we think about the long term and the public's right and protecting that right. So, I think it's an important question to ask. Is this something you're doing now? And could be, because a policy is subject to being reversed. But if you're saying that you believe that this is something the public is entitled to as of right, it's much harder to go back on that. So that is still something that's going to be outstanding, I believe, in our lawsuit, and something we're still going to be fighting for. So definitely a good thing for the public that the city decided to do that. One of the records that we got as a result of the public records request that preceded that decision was the record of a police officer actually who had been arrested in Worcester, an OUI case. He had driven a car onto a pair of railroad tracks and then allegedly taken a CSX truck to try to push the car that he had gotten stuck on the tracks off of it. So it was kind of an interesting situation there for sure. Pursuant to the new policy, we got the conclusion, and it said, that the chief recommended that the officer be fired, and apparently they're in that process now. So it's kind of an open question. Well, I guess it's not really so much of an open question. If they had not reversed that policy, the public wouldn't have been able to see the conclusion where the chief wrote at the bottom, termination recommended. So we see that as a good step forward, and we're hopeful that with this litigation, we'll make it clear, and the city will clearly understand that internal affairs reports are public and need to be released, so that people can make sure that they have confidence in the process.
And that's what makes litigation, like the lawsuit that you're involved in right now, so important, is because this is a policy change, and that's great. And in the short term, day to day, you're now getting access to those internal affairs documents unredacted in the way that the 2003 decision said you should have. But again,
Less
it's a policy decision, right? And it could change tomorrow. So you continue to move forward with the litigation, and hopefully we'll get a decision that has legal authority behind it, saying no, it's not just a policy, it's the law. You need to get this information with every request moving forward. So kudos to you, your colleagues, and the Telegram and Gazette for continuing to pursue this fight. And let's hope that it has a positive outcome. Brad, thanks so much for taking the time to share this story and letting us know about all the work that you're involved in at the Telegram and Gazette, and giving us a little bit more perspective about some of the law enforcement transparency issues that you and I think many of us in communities throughout New England are facing.
Happy to do it, Justin. Thank you very much, and thank you for the work that you guys do. Obviously, so important in this time, these times that we're going through, these interesting times that we're going through. To be really holding up that First Amendment and bringing these issues up with everybody in a way that's accessible. So, thank you.